Hey guys, welcome back to another podcast of Work Comp Talk. My name is Carmen Ramirez, and joining me today is
Bilal Qasim.
a lot of people are like, Bilal Qasim, and who is he?
I am the managing partner and co-founder at Pacific Workers, the Lawyers for Injured Workers. We are an applicants work comp firm that serves all of Northern California.
If you're new to the podcast, make sure you hit that subscribe button. You can listen to the podcast on any of your favorite platforms where you like to listen to your podcast. If you jumped in just suddenly on a YouTube video or you jumped in through our website, it's always best to connect via Apple Podcasts, Spotify, Stitcher, you name it. We're on every episode and app for episodes, and once you subscribe, you get a notification every time we do submit a new podcast recording. So this is actually for the injured workers, people that could potentially want more information in regards to how workers' compensation works. We already know it's a little complex. It's understandable that a lot of people don't know this from the back of their hand. Like, you have to study for this. It's not an easy 1, 2, 3, let's get it out of the way and we're done. And that's why we created this podcast. It's to educate the injured workers of our communities and beyond. So hopefully you've gotten a couple of tips out of this. And today's tip, or today's topic in general, I think it's gonna definitely hit home to many people. And it's a very important topic that relates to workers' comp. It's one of the most important things, and that's permanent disability. There's a lot to talk about. We're going to try to make it as fast as we can, but in a quick nutshell, Bilal, tell us what permanent disability is in workers' compensation.
So permanent disability is used in a lot of different ways. Really, permanent disability is the monetary value of your case. But to understand how you get to that monetary value and what permanent disability is, you kind of have to understand what goes into it.
Right.
And so generally speaking, once you have plateaued medically, meaning the doctors feel as though there's nothing else they can really do for you to improve your condition, be it medication, surgery, physical therapy, injections. They just kind of tap out and say, look, this is as good as it's going to get.
Then you hit the end of the road.
Yeah, they'll say you've reached permanent and stationary status, or the new term for it is maximum medical improvement. Okay. And that means for the foreseeable 12 months, it is what it is. And so once you get that status, then the doctor gives you a whole person impairment rating. And the doctors use this thing called the AMA guides, which is this book that the doctors use to rate whatever residual functional impairment you have left over from an injury. So for example, if you have a shattered elbow or something, and it's healed now and you can't move your arm and extend it all the way, or you have a rotator cuff tear and so your range of motion in your shoulder's limited, or you have a cervical spine fusion so you can't move your neck as much, all of those things would be considered whole person impairment or rateable, that would give you a percentage rating commensurate with the level of disability you have.
Right. So the worse the scenario looks like, I'm assuming the different number that it gives you.
Yep.
Okay.
Yep.
So, and you said this is obviously something that everyone has to go through. So everyone gets through permanent disability. What if you feel completely good?
Well, in that case, you probably won't have a permanent disability rating. Okay. You would probably have a 0. Oftentimes, the doctors will consider a number of factors, not just things like range of motion, but they also use something called diagnosis-based estimates, which means you can have a permanent impairment percentage just based on the fact that you have a certain condition alone.
Got it. So talk a little bit about this rating, this book. How does that actually work? Besides the fact that obviously depending on how much you could move, or just in general, how does this rating come about?
So like I said, once you've reached that permanent and stationary status, then the doctor, in your case, whether it's the qualified medical evaluator or your primary treating physician, has an obligation to determine whether or not you have any residual permanent impairment. They use this book called the AMA guides, and that gives them, we call it a flat permanent impairment rating, or just a percentage. That rating then gets adjusted up or down based upon your age and occupation. The idea is that if you're injured at work and you're a typist, let's say, and you get your leg amputated,
right,
you could probably still sit at a desk and type.
Still do 100% of your work because it doesn't involve your foot.
Exactly. And so maybe your impairment percentage wouldn't be adjusted up much. It might even be adjusted down. Let's say you're a firefighter or you're a police officer or a construction worker or something that's very labor intensive, and you get your leg chopped off, you're probably not going back to work. Right. And so when we apply ratings to the figure that the doctor gives us, it adjusts the impairment up. And same thing for age. Generally, the way the law is structured is that the younger you are, the lower your impairment percentage is. I guess it's based on the presumption that if you're younger, maybe you'll bounce back. You know, if you're 65 and you have a pretty serious injury, you're probably going into retirement. You know, if you're 20, maybe you'll redefine yourself and figure out another path you can go and rehabilitate in the workforce in some way.
So the person that actually does figure out what the rating is defined to be for someone who was just injured is the doctor.
Yes, it's the doctor, but oftentimes both sides fight over it. You know, the thing like the age and the occupation that's used to define whether the impairment gets adjusted up or down is something that's really fought over a lot. You know, oftentimes you'll have someone who's, I see this one all the time, a residential property manager. And so it's someone who lives on a premises. They're there to collect rents and take care of small issues and stuff. And you'll see that the defense always wants to use this lower occupation code that would lower their impairment, because they say, oh, well, they're, you know, a residential property manager. They're a, you know, quote unquote manager. So they probably just sit around and do paperwork.
Wow.
In reality, they're fixing the plumbing, they're doing roofing, electrical repairs, and like all this stuff.
And all that stuff.
Yeah. So in reality, their impairment percentage should be adjusted up because their job duties are way more laborious than the defense things.
That's crazy. So what if you don't get along with a doctor from get-go? I mean, if this person is holding this rating down for you, it's a good thing then that you get along with the doctor.
Yeah, you got to have the right doctor. And we fight over, you know, who the QME is in a case. QME, for those who don't know, is a qualified medical evaluator. And we did a great podcast on those, so check it out.
Yes.
But yeah, the doctor really is the one that determines the impairment percentage. And we see it all the time. You know, the liberal, more applicant-friendly doctors will give higher percentages, and the defense-friendly ones will give little to none.
That sucks.
Yeah.
How do you know what doctor you're going to get?
Well, if you know the doctors, you can make a choice. You know, if you're a lawyer like myself, we've done this for, you know, a very long time, and we know all the doctors. We have personal relationships with a lot of them. We can kind of steer the case in the right direction.
Correct.
You know, someone who's just not familiar with the law or doesn't have a lawyer, they're just going to be throwing darts for the most part.
Like eeny, meeny, miny, mo, I hope I chose a good one, and good luck.
Yeah, and look, you can do some online searching. You can look at Vitals or I forgot, it's like Real Self or WebMD. I forgot, you know, there's all those like review things.
Doctor rating.
But very few of them are applicable to workers' comp, and you really don't know.
Right. So it's kind of like blindfolded. So it's really good that you said, and you mentioned this earlier, there are things you can do about it. For example, when you guys fight because of the age or, you know, the job type, what are some of the things that you've done for clients when it comes to fighting that rating?
You know, we'll do trials, and we'll actually pull their job descriptions, and we'll put on the client and have them testify in court about what their job duties actually were, not just what their title is on a piece of paper.
Right.
You know, the age thing is pretty fixed. That doesn't come up so much, but definitely the occupation. And it can make a big difference in the case. You know, we're talking thousands and thousands of dollars. If someone's got a catastrophic injury, it could literally be the difference in hundreds of thousands of dollars for them.
That's insane. That's like mind blowing just to know that. Obviously, you can go into a standardized way of saying, hey, all of the people that do clerical or data entry just do this.
Yep.
But then they never pick up heavy boxes with files. They never have to walk around. It's like, it's that standardized way of someone saying, oh, well, your job is only entitled to this. And then you get someone to kind of like vouch for you and say, no, this is the responsibilities that this person is doing. And how do you prove that? If it's not, like, let's just say in my job description, I have certain duties set out for me, but at work, in actual work, I have like 5 hats put on me that I do different things. How do you prove that?
We have to have the client testify in court. Generally, you know, they have to go on. We ask them questions. They testify under oath, under penalty of perjury, that these are my job duties and these are what I was doing at the time of my injury, and my job description is not correct, and here's why. And they have to really explain it. Otherwise, the insurance company is not going to take your word for it, and they're simply going to lowball you, right?
Right.
The insurance company is always going to default to looking at what your job title is and going based on that. It's like 100% of the time. I've never had an insurance company say, oh, well, you know, Bob, your job description says you're a property manager, but you know, we should talk about that. Do you do anything else? Do you do plumbing? Do you do, you know, repairs and stuff? Because you should have a higher rating, Bob.
Right.
Never happens. Never happens.
Okay.
It's something we fight over a lot.
That's good to know. So you mentioned, you go through the process of the permanent rating, the disability of what functions you're going to be able to actually do after you've been injured at work. How are you going to bounce back into the workforce and try to defend yourself for the future and lock in that future for you or your family? What happens when, one, you're not okay with the rating, and two, ultimately, what happens if that rating is up to where you can get it and it's still not even enough? Like, are you shit out of luck? Like,
yeah, I mean, every situation's different, but lawyers in particular will fight over the ratings all the time. And it's not just whether or not we think the percentage rating is accurate, also whether or not all the body parts and systems were properly assessed. Oftentimes someone will say, well, I hurt my back and my arm, but the doctor only rates their back and forgets to talk about the arm. And so that's something we have to go back and fight over to try and get a rating for that as well. But generally, if we're not happy with the rating or the body parts involved, we'll take the doctor's deposition, we'll cross-examine them under oath, just as if a client was testifying in court. So they still have the same penalty of perjury that's applicable to them. We can request supplemental reports. We can produce documentary evidence to the QME, like something called a functional capacity evaluation, which is used to test someone's function.
Right.
If it differs from what the QME has in their report. We can present things like diagnostics, x-rays, MRIs to substantiate conditions, which would then have permanent impairment associated with it. So there's a lot of fighting that we do on the back end with the doctors all the time.
It's like a deep dive into everything that happened from day one up until that point.
Yep.
Permanent disability, you were mentioning, is something that you kind of plateaued. And it's kind of like you can't move forward. That's it. You've hit the end of the road as far as your recovery state. At what point in workers' comp does this usually come about?
It's hard to say. Really it is when the doctors feel as though they've exhausted care.
Okay.
That's not all the time, though, right? There's some doctors that'll say, oh, well, I know your arm's missing, but we gave you Tylenol, so we've exhausted care, right?
We gave you Tylenol, gee, thanks.
No, and those are the doctors you want to avoid.
Right.
And that takes it back to there's two sides to this, right? There's a lot of doctors that are insurance favorable, and they will straight up say, like, hey, there's nothing wrong with you. Go back to work, despite someone may be in a position where they need surgery and stuff.
That sucks. I mean, it's just, in general, I guess, trying to figure out what this can actually take you to. We've always said this, and we can't stress it enough, the importance of knowing what you're getting yourself into when you're fighting for a workers' comp case. In this aspect, if someone doesn't know, if I don't have an attorney and I just kind of go with whatever the system is giving me, I'm literally putting my future in jeopardy because I could be lowballing myself. Yeah. How many times, more often than not, have you brought that number up? And if so, you mentioned earlier too, it brings it up by hundreds of thousands. Give me numbers.
Yeah, I mean, every case is different.
Right.
And, it's hard to say. We've helped clients, increase what was offered to them in settlement, from 50 to 100,000, 40 to 180, 75 to 300. It's all over the map. We've literally changed people's lives and the value we deliver, and holding doctors accountable to make sure that they are really exhausting care and that they are assessing permanent disability in the right way. The doctor's permanent impairment rating is set by statute in California when it comes to the monetary value of the case. So anyone can Google these. If you Google search permanent disability money chart or something to that effect, you'll come across it. You'll see that there's a bunch of percentages there, and those percentages all have monetary value based on when your date of injury is. And so if you're going through a comp case and you do it by yourself, at least check that out. If you want more information on what the doctor's ratings are based on, you would actually have to get a copy of the AMA guides. That's not as readily available. But you can check out what's called the PDRS, or Permanent Disability Rating Schedule from 2005. And this is the rating schedule I was talking about that applies to adjusting your injury based on the body parts involved, the age, and the occupation at the time of injury. And so you'll see just by looking at that stuff, it's very complicated.
It's like a formula, right? It's all defined by a formula, and you really have to know how to master this formula.
Yeah, and the formula isn't just going through those charts. The AMA guides themselves are hundreds of pages. It's 18 different chapters divided by body parts and systems, and there's hundreds, if not thousands, of tables that are applicable to different types of injuries and conditions. And you have to know those to understand whether or not someone is getting a fair permanent impairment rating from the doctor.
Shit, I mean, just you telling me this information right now is just like bombarded. I am at the point where it's like, shit, this is actually more than I can handle. If I was not being represented by a workers' comp attorney, it's very, very easy to get lost within this complex system, which we mentioned in the beginning of a workers' comp case. It's not an easy task. It's not a walk around the park. It's something that you really have to know what the heck you're getting yourself into, just to fend for yourself, just to say, hey, you know what? I'm going to secure the best benefits or the best future I can for me and my family.
Yeah, absolutely.
Damn, it's
and having that specialized knowledge, it really makes all the difference. So, for example, even if you had the guides in front of you and you knew every single chapter and every single table to know whether or not permanent impairment associated with the condition is accurate, there's this case, a line of cases called Alvarez-Guzman, and basically these cases are judge-made law, meaning it was litigated in court and fought over and determined that standards were appropriate. And Alvarez-Guzman basically stands for the proposition that a doctor can use any table, any chapter in the guides to rate someone's impairment if they feel it's reasonable, and it reflects the impairment more accurately than it would otherwise. So if you're looking through the guides and you have a back injury, you wouldn't understand that if your standard rating for your back, given your condition, is too low, the doctor has the power to go to the hernia section and rate your impairment based on your inability to lift and things that hernia ratings would be based on, because the doctor feels that's more accurate. And that could completely change your rating.
Right.
In those cases, you know, someone with a small back injury might have like a 5 to 8%. But if they use those chapters by analogy, it can go to like 20 or 30%. And so just having that specialized knowledge to be able to call the doctor's or the court's attention to things like that makes all the difference in a case.
I can see why you would stress on getting a workers' comp attorney. And it's not that we're trying to sell this to anyone or try to tell anybody, oh, you should just get help. It's the reality that you're facing when you're fighting a workers' comp case. It's not an easy system. It's not always a fair system. And dude, this just sucks.
Yeah. It's complicated, and no one's sitting there telling you, hey, look, you know, maybe you should question the doctor's rating.
Right.
I think we get a lot of clients who come into us, unfortunately, after they go to a bad, you know, evaluation and they already have a really low percentage. And it's very difficult to fight that battle. You know, the doctor, a lot of these physicians, they've been practicing for 30 plus years. They've been doing workers' comp for a very long time. They know the AMA guides extremely well. And if they want to screw with you, they can. And they know how to write reports. They know how to testify in deposition in such a way that makes it difficult for us to try and salvage a case that's gone south. And so I think when you're assessing things like permanent impairment, it's important to make sure your case is on track in the right way from the get-go so you don't have to fight that battle later.
That's crazy. Now, I'm glad you talked about, like, you know, at what point we get this taken care of, and if it does go sour, what are the consequences? That was the question I was going to ask you next. But let's just say, okay, you've gotten your rating, the rating's okay, you're good, you're set. Now what? What happens after you get that permanent disability rating? What's the next step?
So once you get that whole person impairment rating and you put it through a rating string where you're adjusting based on age and occupation and body parts and all that stuff, then you end up with your final permanent disability percentage, which has a monetary value attached to it in California. Permanent disability is a lot different than temporary disability. Temporary disability is designed as a wage loss, right? It's designed to compensate you while you're off of work and you can't earn a living. And so the temporary disability rates are 2/3 of what your pre-injury earnings were.
Okay.
Permanent disability is a benefit designed to compensate you for the residual functional impairment you have. And so it's a different species of benefit. It's there for a different reason. And so it's a much lower rate.
Shoot.
Yeah. So, for example, I think the max in California right now is like $1,500 or $1,400, somewhere around there for temporary disability per week. Permanent disability is $290 per week. So significantly lower.
So no matter what type, I guess, gosh, how does that 290 come into play with my rating?
Well, when you have your rating, the rating has a monetary value attached to it. And that monetary value is based on the number of weeks that $290 a week would be paid to you. So, for example, if you have, let's say, $100,000 worth of permanent disability, you would receive $290 paid biweekly typically, so $580 every other week until that $100,000 is paid out to you.
That's crazy. So they're putting like a monetary number ultimately onto what you should get paid.
Literally putting dollars to value your body.
That sucks.
Down to, you know, your finger and your pinky, right? Shit. Everything's got money attached to it. The biggest problem is that every year temporary disability rates get adjusted based on cost of living. So last year, I think we had a 6% or 7% inflation because of COVID and all the money printing the Fed was doing. And so temporary disability rates go up a lot. Permanent disability has not changed since 2013.
Is it ever going to change?
I don't know, but if you guys want to write your congressman, your state assembly member, whoever you need to, I highly recommend you do so because it's not fair to the injured worker. I myself have done what I can. Unfortunately, we're generally small potatoes according to the state of California. And so they're not just going to listen to us. It needs to be a team effort, but workers' comp reform absolutely needs to happen.
That's insane. So permanent disability, you get your rating. They give you that monetary. They tell you, okay, you're worth pretty much your disability is going to be worth this much. We're going to pay it out for you. What next? Like you get the money. What happens if you die while you're getting this money? What happens if it only goes worse after you get this money? Like
both of those things come up a lot, oddly enough. People do die during their case when it's pending or after. If there are permanent disability benefits that are accrued and payable, meaning that they should have been paid, but for whatever reason they hadn't been paid yet, then technically your estate would be entitled to the permanent disability, and you can fight for that. If you're at a point where all the permanent disability that you would have been paid has been paid, but there's some component of it that hasn't been paid yet. So for like that example I gave you earlier, if you're owed $100,000, but they've been paying you the $290 every week, and let's say they've paid like $15,000 of it on schedule, and you still have 85 grand left, and you die, they don't have to pay any of that.
Oh my Lord.
Yes. It doesn't go to your estate. It doesn't go to your beneficiaries or dependents. The insurance company's off the hook, unfortunately.
So it's like, boom, that's it.
Yeah.
You got what you got.
But oftentimes we know how to fight and say that it was due and accrued, and we try and get the estate at least something, We really want to fight for people. In the other scenario, if your condition is worse, you can actually reopen your case.
Interesting.
Yeah. So we have something called new and further disability, which means that once you've reached a disability status, permanent stationary, and your condition later on changes, you can actually reopen the case for new and further disability to say that your condition has deteriorated.
That's good to know that there's that option available.
Yeah, it's a kind of a tight limitation. It's 5 years from your date of injury. So, if you're at 4 3/4 and you think you're getting worse, you better reopen it.
You better say something with the slightest little change.
Yeah, but you'd go back to the QME again, your treating physician, and you would have an opportunity to see whether or not your condition has changed and whether or not there's a new level of permanent disability that you didn't have before.
That's insane. Permanent disability is important. Obviously, it's a big factor within a workers' comp case. And I definitely think you touched a lot of points into what someone should know. What are some of the questions someone should ask an attorney prior to getting this number, or even the doctor? How can they best prepare for this permanent disability?
Just ask them, is this all I get? No, I mean, it's all joking aside, right? I think everyone knows work comp as a system in California is broken.
You'll be surprised. Not a lot of people know.
Yeah. I mean, like I said, the benefit for permanent disability hasn't changed in now going on 8 years. It's completely inadequate. But we have what we have. It's a system, and we have to do our best to work within that system. And so it's important that you're aware of what you're entitled to. And when you're meeting with the doctor, for example, it's best to always ensure that the doctor is evaluating all the body parts that you are saying are injured. I have a number of clients who come back and say, oh, well, I tried to tell the doctor that it was my arm and my back, and the doctor said, I only want to talk about your back today. And that's not right.
Yeah.
That's not right. And when it comes to your lawyer, you should always talk to your lawyer about what's aching and what's giving you pains and what's problematic, because I'm going to sound old when I say this, but squeaky wheel gets the grease, right? And that means you gotta make it known, right? You can't sit there and be quiet. You got to speak up for yourself. And if you're having issues with your doctor or certain things are not getting addressed properly, you need to bring those to the lawyer's attention so that they can help you.
Dude, this is like a lot of information dumped on someone, especially if they're listening to the podcast right now. I'm still at the point where it's like, shit, this is important. This is something heavy weighing on a person that's going through a workers' comp case. I can just imagine someone that's actually going through the pain and having to deal with all of these numbers, the factors that are going to play a role in your future. And, you get your permanent disability, you get the payments. You only get a certain amount. You go back to work.
Yep.
Does that affect in any way, shape, or form?
Sometimes. It depends on the case. Ultimately, if you've gone back to work, and you're back in your normal job, for example, it wouldn't really change things per se.
Okay.
If you're displaced from your employment, then you're entitled to something called a supplemental job displacement benefit, which is a voucher for job retraining or reeducation. If you're eligible for that, then you get something from California called the Return to Work Supplement, which is another $5,000 payment. And so
You said if you're eligible, so that means not everyone is eligible for it.
correct. So to be eligible for the voucher itself, you have to be displaced from your job via permanent work restrictions, meaning the employer is obligated to offer you permanent modified work within 60 days of being deemed permanent and stationary. If they don't, you get the voucher.
Got it.
And so technically, even if you go back to work full duty, but your employer failed to offer you permanent modified work within 60 days, you could still force them to get the voucher. And you can actually get penalties and sanctions for it.
That's good to know.
But again, you need to understand that that's something you're entitled to,
Right.
To do that. But then the state's program, the Return to Work Supplement, requires that you, one, get the voucher, and two, that your injury was after January 1st, 2013.